Most people think the lawsuits are about dramatic courtroom speeches where a judge decides who is morally right, but that almost never happens. Civil litigation is actually a brutal logic puzzle where the first person who misses a procedural deadline disappears from the case entirely. No debate, no speech, just a rule that quietly ends the game. And the lawsuit is therefore not a morality contest, but a sequence of procedural gates. And each gate is binary. Either jurisdiction exists or it doesn't. Either service occurred or it didn't. Either an objection was raised on time or it was waived. Was destroyed, either statements just remain consistent across the filings or the record begins to contradict itself. And the moment one gate closes, the court never reaches the moral argument people thought the case was about. And this is the first viral twist. Most people never realize the procedural game is the main game. And the courtroom speech, the part people imagine from movies, is usually irrelevant, since more than 90% of civil cases never reach trial at all, meaning the real contest occurs in the filings, timing rules and jurisdiction triggers, and admissions quietly locked into the record just months earlier. And this is where inexperienced defendants began making spectacularly just confident mistakes, since SU litigation is about defending themselves emotionally or explaining motives to a judge, while the rules quietly treat their silence as an admission, and their delay as a waiver, and their confident procedural ignorance as consent to the very court power they insist does not exist. And in other words, the party that wins early is usually the one who understands a single brutal principle, controls the record first for the binary positions, and let the rules themselves corner the defendant has admitted just something in a pleading or just failed to object in the correct procedural moment. And the court often treats the mistake as irreversible, regardless of how just persuasive the later explanation sounds. And the rules are not sympathetic to outrage. They are mechanical. So take service of process under the federal rules, which explicitly states that a defendant's good cause for serving a waive service doesn't just include a believing that lawsuit is groundless, frivolous, or filed in a wrongful court, meaning the rules openly anticipate the most common emotional reaction from defendants and dismiss. So it's legally irrelevant, which is just a legal equivalent of the rule book saying your outrage doesn't just change the procedure. And once you see litigation through this lens, the entire system begins to look less like a search for truth and just more like a high-stakes set logic problem. So where the court's authority is conditional, procedural statements become binding facts, and every misstep quietly converts the opponent narrative into the very version the court is allowed to accept. And here comes just a twist that makes many confident litigants look ridiculous, and in hindsight, even when someone is technically correct on a powerful defense, so the timing rules can still defeat them. In January 2026, the Supreme Court confirmed that the reasonable time requirement is a Rule 60C1 applies even to motions arguing that the judgment is void under just a Rule 6B4, meaning a party can prove a judgment was legally defective and still lose simply just because they waited too long to challenge it. And think about how strange that sounds outside the legal system. A person can be right about the defect and still lose the case anyway, not because the law disagrees with them, but because the rules decided they spoke too late. And once you understand that principle, the entire mythology around the lawsuits collapses. Litigation is not just primarily about persuading a judge that you are morally correct. It's about surviving a chain of procedural conditions where every delay, every inconsistency, and every missed objection quietly converts confidence into defeat. While the rulebook calmly just records the outcome, and many defendants are actually rhetorical folk, not just legal defenses. And if a defendant cannot just time claim to a rule, a statute, or a precedent, so then the argument is not a legal defense, but a narrative noise designed to blur prerequisites. And a basic pleading logic under Rule 8 and Rule 12 And just in general, participation in litigation can destroy jurisdiction objections, as if defendant litigates without raising jurisdiction or service defenses early, then the law treats later objections as waived, even if the objection might just otherwise have been waived. Just Rule 12H1 waiver doctrine. And a silence can legally become an admission. If a party ignores a request for admissions, then the request statements are deemed admitted and can become the factual basis for a summary judgment, Rule 36. And evidence destruction analyzed just with structural just logic tree. If ECI disappears and cannot be just restored, courts analyze prejudice first. If intent to deprive is proven, as a court may allow adverse inferences or even just default as a Rule 37E spoliation framework. And default judgment is procedural gravity. If defendant fails to respond, the court can enter a default even when the underlying claim might be weak. Again, it's not applied to the government defendants, but just overall. Litigation punishes just procedural neglect more than rhetorical confidence, and a Rule 55 is just all about it. And a void judgment argument still has a clock. If a party claims a judgment is a void for defective service but waits too long to challenge it, courts can deny relief, because Rule 60 requires motions within a reasonable time, and Rule 60C1, Coney Island, just out of parts with Burton, just exactly demonstrates that part. And arbitration clauses can erase actions. For example, if a contract contains a valid arbitration clause with a class waiver, then courts often enforce individualized arbitration instead of just collective litigation. But arbitration can explode through mass filings. If thousands of individual arbitration demands are filed, administrative filing fees can become massive, just turning arbitration from a shield into a financial pressure point. As a mass arbitration litigation reports. Another thing is the corporate defendants often win by geography, as if a corporation is not at home in a forum, just in general jurisdiction usually does not exist, meaning a case can fail even if the conduct was harmful, and the wrong corporate defendant can kill a case unless Rule 15 saves it. If a wrongful but related entity is sued, relation back doctrine may revive just the claim only if the proper defendant knew or should have known it was the intended target. Another thing is a winning liability, which is not the same as collective money. If defendant lacks assets or hides them through a corporate structure, then a verdict may exist, but enforcement becomes a real battle. Judgment enforcement law is state-specific. Again, courts are now more advanced with this, but it generally likes the issue if this happens in your case. Another thing is suing the government requires a selective waiver pass. If a plaintiff sues without identifying a correct statutory waiver or exhaustion requirement, the court may dismiss even the strong claims. Again, it happens a lot in FTCA claims. Different defendants usually rely on completely different strategies. If you understand the pattern, you can turn each one into a logical trap. When the defendant is individual, the usual strategy is simple: deny and delay as long as possible. And the counter is procedural discipline, and establish the service early and force written admissions, because here is a rule people miss. Ignoring lawsuits doesn't just defeat it, it often just creates a default judgment. And when the defendant is a small business, the strategy is confusion, and they blur the line between the owner and the company, and they claim you sued the wrong person, but contracts reveal the truth. So if the signature, insurance, and payments records point to the same entity, the confusion disappears, and suddenly the document can contradict their story. And when the defendant is a large corporation, the strategy changes completely. So they rely on jurisdictional fights, arbitration clauses, and aggressive motion practice. And their strongest weapon is often hidden in the contract itself, because the agreement you clicked might have just already chosen the court or eliminated the court entirely. And in other words, so the lawsuit may have been decided before it was even filed. And when a defendant is a government entity, so their strategy is immunity, they rely on exhaustion requirements and procedural gates. And the trap here is understanding one thing. You do not sue the government, you sue a legal waiver with a checklist. Miss a checklist, and the case disappears. And many defenses are not legal arguments at all. They are rhetorical fog. Take the claim, your case is frivolous. If the claim were truly frivolous, so the defendant would welcome discovery in summary judgment, and delay only makes sense if the facts are dangerous. And another common claim is you didn't just serve improperly, but the rules say something just important. If the defense is not raised in the first response, it's waived, and which means the objection disappears even if it just once existed. Then there is a classic. I don't remember. That sounds safe. Until requests for admission arrive. Because silence converts uncertainty into binding admissions. And another tactic is you can't prove damages, but damages and liability are separate questions. And a defendant may attack the remedy, but that doesn't just erase the underlying facts. And finally, the phrase people love to use. This is just a technicality, and the law prerequisite is not a cosmetic. Jurisdiction and service determine whether a court has a power. Without them, the case never starts. And there are also patterns in how strong cases are built, so think of them as sequences. The first sequence is a gatekeeper trap. So before anything else, check 6 things. The statute of limitations, the correct defendant, jurisdiction, service of process, arbitration clauses, and exhaustion requirements. And the most lawsuits never fail on the facts, so they fail on one of these gates, which is why the real lesson is simple. Most lawsuits die before a judge even reads the story. And the second sequence is the binary admission strategy. Instead of open questions, use precise admissions. Dates, documents, communications, and turn uncertainty into yes or no answers. Because the most dangerous question in litigation is one your opponent cannot answer without losing something. And the third sequence is a cost reversal. Like people assume the richer party always win, but sanctions, fee-shifting statutes, and discovery penalties can flip that dynamic overnight. And sometimes the side trying to bury you in the legal costs ends up just paying you yours. And the fourth sequence is a default twist. The loudest courtroom victory is often silence, and the silence of defendant who never answered. And because ignoring litigation doesn't just punish a weak case, it usually just hands the other side a judgment. So consider a cruise ticket case. A passenger sues locally just after an injury, but the ticket contains a forum just selection clause, and the lawsuit just must be filed somewhere else entirely. And a fine print quietly decides the court, or the class action illusion. Consumers try to sue together, but the contract contains just arbitration clause, and the courtroom disappears, and the case moves into private arbitration. And then there is a silent admission disaster. A party ignores a request for admissions, and the unanswered statements become facts. And those facts support the summary judgment, and deadlines just quietly decide the outcome. And finally, so the missing emails problem. Evidence disappears. Now the courts must decide whether the loss was accidental or intentional, and under the rules, losing evidence can mean losing the case. And one final forum in legal analysis. Attack contradictions, not people. Say things like, this argument contradicts Rule 12. The defense was waived under Rule 12. Their story cannot coexist with their own filing, and facts are stronger than results, and contradictions are stronger than accusations. So the real lesson is simple. Lawsuits are not won by the best story. They are won by the person who understands the rules before the other side even realizes the game has started. And if you want more breakdowns of the legal traps people miss every day, subscribe. And because the most dangerous moves in litigation are the ones nobody notices until it's too late.